Socio-Economic Rights and Accountability Project has sent an open letter to President Muhammadu Buhari requesting him to urgently rescind assent to the Companies and Allied Matters Act 2020 and to send the legislation back to the National Assembly to address its fundamental flaws, including deleting the repressive provisions of the Act, particularly sections 839, 842, 843, 844, and 850, contained in Part F of the Act, and any other similar provisions. The organization wants the Registrar General of the Corporate Affairs Commission, Garuba Abubakar, and Attorney General of the Federation and Minister of Justice, Abubakar Malami, not to implement or enforce the CAMA 2020 until the legislation is repealed by the National Assembly. SERAP's Deputy Director, Kolawole Oluwadare, said with the contentious provisions, the government now has discretionary powers to arbitrarily withdraw, cancel, or revoke the certificate of any association, suspend and remove trustees, take control of finances of any association, and to merge two associations without their consent and approval of their members. SERAP advises the government to improve the legal environment and civic space rather than pursue initiatives to restrict the enjoyment of citizens' human rights. Now let's get more on this. I have joining me the Deputy Director of Socio-Economic Rights and Accountability Project, Kolawole Oluwadare. Good to have you join us this hour. Now we've seen the rejection of this section of this bill or this act by the religious institutions. What are your concerns with this act?
Our concerns are basically what we have written about to the President in our letters, particularly the provisions that derogate from the fundamental rights provided to Nigerians by virtue of our Constitution and Nigeria's international human rights obligations, particularly Part F of the new Company and Allied Matters Act 2020, specifically sections 831, 839, 840, to 844 and 850 of the Act, which affects, do not only shrink the civic space, but derogates from the rights of individuals and to form associations and to run those organizations at the deemed fit, albeit within the confines of the law.
So, but some would argue that the courts are there to challenge some of these actions if and when they do happen. So why is there this public outcry over the president rescinding his assent to this act?
Our position is clearly justified, given that some provisions of the Act derogate from that right of individuals and are not subject to the judicial process of the court, specifically Section 839, Section 1 of the Company and Allied Matters Act, do not give that right to the court. It provides that it gives the Commission of what we see as unlawful rights and arbitrary rights to determine what is public interest, and in so doing suspend trustees of incorporated organizations, including NGOs, religious organizations, and even members of organizations like the Nigerian Bar Association, which are members of incorporated trustees. So that is clearly against the law, against due process, and what will be the principle of checks and balances. And of course, it's clear, as has been said, that when you give such absolute powers, it's likely to be abused.
So, first of all, is there a precedent to the president rescinding assent to a bill he has already signed? And if it refuses to do so, what is the next line of action of your organization?
There is no precedent, in fact, in terms of history, in a historical precedent in Nigeria for doing that. But the powers of the president to assent under Section 58 of the Constitution clearly also gives him the right to withdraw his assent and form a basis for when the National Assembly can begin a repeal of those offending sections, particularly given the power of the president to be in the interest of, to act in the interest of Nigerians. And these associations registered under Part F are Nigerians too. And so the president must be able to protect their interests. And naturally, in international law, when countries assent and sign treaties, of course, countries are also empowered by law to withdraw and revoke such assents. So it's not out of place for the president to do that. And clearly we had conveyed our decision to approach the courts to compel the government to do what is required as we've asked. And that also includes sending what is called a pre-action notice to the Corporate Affairs Commission as in fulfillment of Section 72, Section 17, Sub 2 of the new act into go to court within 30 days if our requirements are not met.
We'll continue to monitor how this plays out. Deputy Director of Socio-Economic Rights and Accountability Project, Kolawole Oluwadare, thanks for talking to us.
Thank you very much for having me.